everybody can hear me. This is going to be a very fast-paced presentation. The presentation will be available on the association's website, so don't feel like you need to take notes. It'll be on there. I think it's going to be very informative, but again, very fast-paced. And let me just say that for the audience, please talk with Lee and the staff if you have some comments on speakers, topics, other things with this year's conference. Give them some feedback so that next year's conference can be even better. So with that said, see where I need to, how does this work on getting the PowerPoint moving? Okay. I have handout materials at my table that will give you information address-wise and all of my stuff. I'm not an attorney. I don't profess to give legal advice or anything. I'll leave that up to Tony Hubbards of the world that's going to give you a good presentation at 2 o'clock today. But I will give you one bit of advice from Mark Twain. Buy land, they're not making it anymore, which emphasizes why you need to be very careful with what you do with your land, because you may be encumbering it by signing a document that lasts beyond your lifetime. Talk to an attorney. Opening remarks, what a landman does. I work with oil and gas leases, coal leases, right-of-way agreements, other things related to the mineral, but I also work with right-of-way agreements, surface use agreements and such. So while the emphasis today is going to be on leasing of your mineral rights, I'm going to touch on surface use a little bit. So if you're a service owner that does not own your mineral rights, we're going to touch on that a little bit. But, and you probably heard this before, ownership of property is like a bundle of sticks. But the most important stick in that bundle is the mineral rights. If you don't have those mineral rights, the rest of your sticks are subject to the rights of the mineral owner. A reasonable use of surface in order for the mineral owner to develop their rights. And as to all of these other sticks, whether you've got a hunting lease, timber lease, oil and gas lease, coal lease, whatever, each time that you do something, one of those sticks disappears. All the more reason to be very careful with what you sign. Not going to get into, and this may be, okay, these are the typical types of contracts you're going to deal with your property. Just want to say that there's one in particular, keep an eye out for, royalty deeds. South Alabama has seen, I'm told, a little bit of a scam going on where people are asking you to sign away your royalty interest, when in fact the document would have the effect of you signing away your mineral rights. Talk to an attorney if you get one of those. Make sure that you're not signing away something that you shouldn't be. Great publication here through the Alabama Geological Survey. Marvin Rogers wrote it. Marvin's the former director of the association and all. Good heads up on giving you tips on how to execute an oil and gas lease, what to look out for. And if you have a complaint about a landman, such as myself, who is a member of the American Association of Professional Landmen and or other associations, I'm giving you some information here on how to follow up and file a complaint. If you're dealing with a right-of-way agent, say for Alabama Power Company or SONAP or the Alabama Department of Transportation, they may be members of the International Right-of-Way Association. I don't have that up here, but there are ways that you can follow through, and if somebody's not treating you right, file a complaint against them. We're not licensed or registered landmen are not in the state of Alabama. This is going to hit on some of the different terms, some of the different provisions that you're going to find in oil and gas lease term. If you're going to negotiate, you may want a shorter term than what they've suggested. They want 10 years, ask for 5. If they want 5, so they'll give you 3 for the same amount of money they're offering you. Royalty, if they offer you a 1/8, ask for a 6, ask for a 3/16. It's all negotiable. Post-production deductions from royalty. The typical oil and gas lease gives the lessee the right to deduct from your royalty the cost of getting that gas from the wellhead to the purchasing pipeline. And I'm not talking about the cost to drill the well, and equip the well, and operate the well. It's kind of like raising a crop of corn. You incur a cost to get that corn from your field to the market. And you would share, so if it's 1/8 royalty lease, you're going to share 1/8 of those costs. But you can negotiate that where you don't have to bear that. And for those of you who have existing oil and gas leases, look very closely at your check to make sure that you're not being charged too much for that or anything. That's one of the things I do is audits. And every client that I've worked for where I've done an audit, they've been overcharged on post-production expenses. A lot of things I'll comment on an oil and gas lease or coal lease or even a surface use agreement indemnification. You want to be indemnified, whether you're the surface owner or even the mineral owner, for what's happening out there. Be very careful of that. Not just weeds. I want to touch on that because I have seen firsthand where, say, an oil and gas company went into an area, put in a pipeline. There never was a sprig of kudzu out there. Lo and behold, 2 years later, you got kudzu growing. Kudzu, Japanese honeysuckle, and especially, I'm going to mispronounce it, what is it, Kogan grass, with that coming in, you may want a special provision on your right-of-way agreement or your oil and gas lease, anything that's going to affect the surface. Require that operator to have their machinery cleaned before they come on your property. That's a standard requirement out west where noxious weeds are such a problem and an issue where it's competing with water resources. And you also want these provisions in your agreement to survive the life of the agreement. Because you may come up realizing in notification that you've got an environmental problem or something else out there, but your lease is expired. You still want your lessee or grantee to be responsible for making it right with you. Not going to talk a whole lot about cold drill permits and all, but you do, if you're approached, say, if somebody wants to test drill for coal or oil and gas on your property, look at it in the big picture. What is your expectation of going to happen? Because they may go out there and clear 10 acres. They may go out and tear your property up. You want to be real specific about that, especially as to reclamation, because you may want trees planted back. Well, what type of trees? What's going to be the fertilizer mix and all? On coal mining leases, post-mine land use, for any of you that have a situation where your property is going to be surface mined for coal, be very knowledgeable about how it's going to be reclaimed. You want to specify in your lease whether it's going to be reclaimed into forest land. If it's in pasture now, make sure it's specified it's going to be reclaimed in pasture. There is a difference by the federal law between pasture land and grazing land. Pasture land is going to be put back where you can grow hay and all. Grazing land is basically whatever's reclaimed to, whatever grows out there is grazing land. And that is not in your best interest. Indemnification in permanent water impoundments. If you own the surface, the lessee, your coal mining company may want you to keep those ponds. And you know, at first blush, that's a great idea. You want a pond, the deer can come up water, you may want a fishing pond, and it's going to save your mining company some money by not having to reclaim those. But when the bond is released from that property, and you're left with a pond 2 years later at the dam breaks, well, guess what? ADEM's going to come knocking on your door for all the siltation that flows down. So if you want to keep a pond on your property that's been surface mined, you may want some extra compensation from the mining company, or you just may not want to incur that potential liability. And believe me, I have seen ponds break after bonds have been released. On surface use agreements, one of the things that I've talked about with several people over the course of last night and this morning is, let's just say if you have your minerals and you're being approached, and the surface, and you're being approached for an easement, be it a power line, road, pipeline, that's going to sterilize the development of your minerals underneath your property that otherwise would be mined by surface mining method and possibly even underground mining. It's oil and gas, it can still be developed. But talk to your attorney about the impact of granting a surface use easement that could sterilize or cause your underlying minerals to be left alone. Abandonment. Too many people sign right-of-way agreements that don't just say something like, if the use is abandoned, say for 12 months, it's considered abandoned. Too many people grant right-of-way agreements that go into perpetuity, and then it may no longer be used, but then how do you prove it? So a lot of things can be worked into an agreement. If you own the surface and somebody comes to you, you sign a damaged settlement agreement, say they want to put a well site on you through this dominant right of the mineral owner, they want to be a good neighbor with you, they want to pay for damages and all. But talk to your attorney, be very careful about those, because you may be waiving your rights to future damages, because you don't know what's going to crop up later. Tony could probably tell you, at common law, you may still have recourse against somebody. Be very careful how you do that. And again, what's the reclamation plan when they get through using your property? One more quote I'm going to leave you with. Life is a learning experience only if you learn. I'm hoping that my presentation today, and again, this has been a very fast one, that you picked up on a couple of things. I wish we could have gone into more detail, but we want to keep us on schedule for lunch. And again, give feedback to the staff and all of the association on, maybe you want a topic presented next year that you haven't heard before. Maybe a topic like Tony's done before on timber law. maybe it's time for some of that to circle back to you for your benefit. So get good feedback, and I hope y'all picked up on something today. And in closing, just want to say, talk to an attorney before you sign something. Consider my services as, look at me as a mentor or a coach or a tutor, because I can help to get you speed on some things so when you do sit down with your attorney, you're more knowledgeable. And consider joining NAGRO on here if you are a mineral owner. And that's it. I don't think we have time for questions, so we can stay on target.